Giaso Kanien'kehakeh, Kanien'kehakeh Nyagwait Shouta. Greetings of peace. My real name is Kanien'kehakeh, and it means she's visiting. And my nation, I'm Mohawk Nation, Bear Clan, from the Haudenosaunee Confederacy, and my GST name is Beverly Jacobs.
And in our first scenario, someone's gone missing. What do you say to families? What can they do?
Well, my first suggestion is to trust your instinct, to trust your gut immediately. That if you really believe that they are missing, that you contact everyone that you know, your community, your family, your leadership, the police, everyone, and get it out there to everyone as soon as possible, as soon as you're able to get to the place where you feel comfortable. Because I know a lot of times that if somebody's gone missing, sometimes there's a little bit of hesitation, or maybe you're hoping that they're gonna come home any second. But once you sense that instinct, that gut instinct, that you know that they've been gone too long, and you haven't heard from them. You know that you hear from them all the time. So as soon as you feel that, then contact everybody that you know. And if you're on Facebook, to get it out on social media, or even to get it to people who you know is on social media. Those are the immediate things that can be done. And also making sure that you contact the police immediately, and push it. If the police are going to tell you that, well, maybe they'll be home and they want to run away, then that's crazy. Then you make sure that you push them to make sure that they get it out there as well, because that's their job.
Can you talk a little bit about postering?
Postering, yeah. I mean that too is getting the pictures out of your loved one, all kinds of different kinds of pictures, so that people are aware of what they look like, of and being able to put them out in different places, whether you're in an urban center or on reserve or in a community. And that's where people are going to help. I think this issue is a lot of people are aware now, and I think as soon as you get it out there, that people are willing to help, and being able to get those posters. So having the resources to get pictures printed out, finding people who are able to get that done right away, and get them out all over.
What do you think about going to mainstream media, and what should people be looking out for if they choose to do
Well, I think if people do choose to have a press conference right away, that again, that's also part of what can be done as well, is getting the voice out there in the public and into the media, and being aware that sometimes when you're making a decision to go public, that it is very public, and that people may say things, that may do things that you may not agree with, and I think just taking a stand and keep pushing it. It's hard. It's really hard because it's also so very emotional, and being aware of what media is looking for. Sometimes it can be very sensationalized, and that's all they're looking for. and being aware that your voice is very strong. So I think as long as you're able to maintain and having people around that support you, and also is aware. I mean, a big part of media is training. I mean, I myself had to go through lots of training to speak to the public and through media. And so being aware of how to answer questions, but what it is staying on point, being aware of what it is that you want the people in the public to be aware of. And I think the biggest, as soon as someone has gone missing, is getting your loved ones' pictures out there. And also a message to them as well, because they may be missing, and sometimes they are found. So I think it's really important that your message is also to them, to let them know that they're loved, and that you really want them to come home, and that you want to talk to them, reach them out immediately. So I think that's really important too.
An ongoing investigation.
Well, I think that's probably the most emotional time, when their loved one is found. I think the first thing is to make sure that the supports are there. Whatever supports are needed, whether it's that spiritual help, the ceremonial help, the whatever it is that helps them through that process. And when there is a murder, then it becomes a whole other system that's involved. And the whole other system that's involved is that criminal legal system. And when there's an accused person, depending on who the accused person is probably the most difficult emotionally to have to deal with. And because it also impacts not just your immediate family, it does impact the whole community. And so that's where it gets really complicated, really all those emotions come in, the anger and the hurt, and knowing that someone has taken the life of your loved one. And when you do have to go through that process, and that person has been charged, and that whole other system takes over, basically, because what happens is that accused person actually has more rights than anyone, because there's a whole legal process that allows them to have a whole charter of rights and freedoms that protects them from the system. So policing's involved, the Crown attorneys are involved, evidence is collected, and that's probably the most part of the process that's the most devastating, is when they do collect all that evidence, because that's when the details, the ugly, gory details of their murder is being told in courts. And being prepared for that, I think is the most important, because when it does end up going to the courts and the murder trial, is the first time that you'll ever hear those ugly, gory details. And I think being prepared for that will help, So having the supports there all the way through that process is the most important. Having people around that can explain the system, having people around that can explain the language, because within that legal system there's a whole other language that's being presented in the courts, and a lot of times you may not be aware of what they're actually talking about. And so hopefully what I can help you with is to explain that process. Yeah.
The overall.
Okay, so the whole Canadian criminal legal system is a whole process in itself. It's very colonial. It was based on patriarchal colonial values. It was never part of Indigenous. It was never part of Indigenous thought about how we deal with conflict. So it's a whole other process that our people are forced into. We don't have any other option at the moment to address these horrific crimes that are occurring. So when an accused is charged, so first the police have to do their job. They have that, like I said earlier, about collecting evidence. So the police are the front line in the criminal legal system. And so they're the ones who have to collect all that evidence. And because the principles of criminal law are that the Crown has to prove its case beyond a reasonable doubt, that's where the police come in and gather up all that evidence, and they have to present it to the Crown to make sure that their case is proven beyond a reasonable doubt. So then it becomes the Crown's decision whether or not they're going, what crimes they're going to be charged with. So there's a whole federal criminal code. So the criminal code is where all of the offenses, federal offenses, are laid out. So crimes like manslaughter, first degree murder, second degree murder, assaults, those are all federal crimes. They're codified in the criminal code. So that's where the Crown has to make a decision whether they're going to charge someone with manslaughter or whether they'll charge them with second or first degree based on the evidence that the police bring forward. And that's when it also becomes very difficult, because we know as family members whether someone actually makes a decision to kill someone. And because of that colonial system, and they make a distinction between first and second degree murder, and it's all about intent, and whether or not it was planned ahead of time is what makes a difference between first and second degree murder. And so if they find that, and they think that it wasn't planned, then that's when they charge them with second degree murder. And I think that's where it becomes very difficult, because then that's when also there's a process of sentencing, and there's differences between how an accused is sentenced if they are convicted of first and second degree murder. And really it's more about whether how much time they can spend in jail before they can apply for I can't think of the word. Parole. Yeah. So it's either, I think the maximum is 25.
Recap
Yeah.
that question.
So
difference between?
So the difference between first and second degree murder and the sentence is how much time they spend in jail before they can apply for parole. So the maximum for 2 years, the maximum for second degree murder is a maximum of 15 years before they can apply for parole. They can get life. So a person can get a life sentence for second degree murder, but they can apply for parole after 15 years. And if they are convicted of first degree murder, they can be charged for life in prison, but can apply for parole after 25 years. So there's really only a difference of 10 years between second and first degree murder. And so that too causes some difficulties for families when they hear that he may be out in 15 years. But again, it's the process internally. Once they're convicted for life, there's a whole other process again. Once they are convicted and they're in jail, they have to go through parole boards and parole board hearings. So that's later. So what I want to explain is the actual criminal legal trial. So like I said, the police are the front line. They gather the evidence. The Crown makes a decision of whether it's manslaughter, first degree or second degree murder. And then the accused is charged. They have first a bail hearing to determine whether he can get bail or not, and it depends on and so that's the first hearing. So someone could come forward and offer bail for the accused, and he may get out. So again, that's up to the judge to determine whether or not he does receive bail. And I would say in most instances, they don't get bail. And so they are serving their time right from the time that they're charged until their actual trial. And a lot of times, because the accused is able to use the system, there's like first appearances, there's adjournments, there's a whole other the system itself, because of the way that it works, and because the accused is actually one of the principles of criminal law, is that they're innocent until they're proven guilty. So they are in jail, and they're innocent. That's how the system works until the Crown is able to prove beyond a reasonable doubt that they're guilty. So that's what all of the whole process identifies, is that game. I call it a game. It's a game between the Crown and the defense lawyer to determine whether or not he's innocent until the Crown is able to prove him guilty beyond a reasonable doubt. And what does that mean? A reasonable doubt, it means that if there's any doubt whatsoever that he may be innocent, then he's acquitted. So the Crown really has to work hard to make sure that the evidence that they're bringing forward is enough to ensure his guilt. So that's where it makes it difficult. And also part of that process is that the Crown doesn't represent the victim. The Crown represents society. So when you see the wording R versus the accused's last name, so R represents Regina is the word they use, but it represents the Crown, the Queen. And so they represent the Queen, they represent society in general. They do not represent victims of crime. They do not represent families of victims. So they do not represent you. And that's also part of the difficulty in the process, is that families are left out, really. Once in a while, I think when you have really good Crown attorneys and they're able to develop a good relationship with the families, I mean, that's what families can demand, to have that relationship with the Crown. But again, the Crown will tell you that they do not represent you, that they have to do their job in representing all of society. And so that too is part of the problem, because what happens is that if you are a victim of crime, if you are the victim, the only way that your evidence ever gets into the court is through evidentiary rules. And that is a whole other process. It's a whole other process and rules of evidence that are presented. So when I say there's different processes, and I said there's first appearances, there's adjournments, there's pre-trials, and then getting to the trial. So that could take years by the time we actually get to trial. And during the trial, again, like I said earlier, that it's the first time ever hearing that ugly, gory, horrible details of how your loved one was murdered. And so being prepared right up to that point is needed, and having people to support you in the courtroom during those days is really important. And I know that there's victim services that are supposed to be available for families, but I don't always think that they understand the trauma that families are going through, and I don't think they always understand that families don't understand the language within the courtroom. And hopefully that'll change, as we're going through this process now, that people are becoming aware that victim services needs to change when it comes to murder trials. And so that again is where assistance is needed from people who are aware of what is being presented in the courts, because sometimes they have little mini trials in a trial and they ask you to leave, and a lot of times families are wondering why are they asking us to leave. It's because the Crown and the defense lawyers have to do a little mini trial with the judge to determine whether certain evidence is applicable. So let's say the accused had a confession. So basically, the Charter of Rights and Freedoms says that you have a right to not be self-incriminating. So it means that you have a right. If somebody forces you to tell you what happened, that's where evidence in the court, where the Crown and the lawyers have to make a decision whether or not that evidence can actually be brought into the trial. And there's other things that happen, and most of it is those evidentiary rules to determine what can actually be brought into the trial. So if they determine in that little mini trial that a confession isn't constitutional, then they can say, the judge can determine that it's not applicable, and they won't use it. And so again, that confusion when we hear that someone has confessed and then they end up in the courtroom, that confession is thrown out. So that causes a lot of confusion and a lot of anger, because then all of a sudden it's not applicable and it's not used. So that happens a lot during the criminal trial. And then the judge has to make, and also determining whether or not the accused has, because of the charter and because of the offenses, can determine whether or not to just have a judge hearing it, or whether they have and choose a jury And I think when there's another whole other process for when a jury is brought in. So when a jury is brought in, that's a whole other process. And the whole other process is determining the jury members. So both the accused lawyer and the Crown, right, when people are summoned to be jury members, they also have to determine whether or not jury members are biased. And they could already have an opinion of the case even before coming and being a jury member. So that again is a whole other process before the actual trial to determine who the jury members are. And again, there's case law, there's law that's been determined that even juries can be biased, and there should be Indigenous jury members that are part of the jury. A lot of times that doesn't happen because there's supposed to be a jury of your peers, and that's how the system works, or supposed to work, but a lot of times it's not working. But again, that's for the accused. What else?
When is it always a judge, or what determines whether it's judge or jury? Or?
It's up to the accused and the accused lawyer to determine whether or not they want the judge to determine, or if they want a jury. It's totally up to the accused to determine that. So once the trial is over, and either the judge or the jury is making a determination of guilty or not guilty, they're not, part of the process is they have to look at the law. And part of that process is applying the facts to the law. It really has nothing to do with emotion. It has nothing to do with spirituality. It has nothing to do with the spirit of your loved one whose life has been taken. It's a game. To me, it's a word game. It's determined about a whole legal system that it's not only not working for us as Indigenous people, but it's not working as a system for all peoples. So again, it becomes part of the struggle. So if a judge comes back or a jury comes back and determines that the accused is not guilty because the judge hasn't proven its case beyond a reasonable doubt, that there was doubt in his innocence, his or her innocence, and he's acquitted, and he comes back into the community, and according to that system, it's over. If they determine that he's guilty, then there's a whole other process of a sentencing hearing. And the sentencing hearing this time is a whole other process. And again, that process allows for the accused to have certain determinations of what's presented during the sentencing hearing. And there's a case that was called Canoe. And Canoe allows for the history of the accused to be presented to the judge to determine their sentencing and what is required. And then that's when the judge determines how many years, whether it's first, if there would already been charged with either second or first degree murder, but the judge would determine in how many years that they would have to spend in jail and how many years that they could apply for parole. And so that's the end. Once the sentencing hearing, or once the judge determines determines whether they're guilty or not guilty.
Can you just say the piece about Gladue again, but preface it with if the accused is Aboriginal?
Right. So, actually, the Gladue case that came to the Supreme Court of Canada stated that an accused person who has been sentenced has an opportunity to present their history, their life history, into their sentencing process. And it does apply. In the criminal code, it says that it applies to all peoples, but especially Aboriginal people, because of the history of colonization and the history of residential schools and the child welfare system and all of that may have an impact on an accused person. Because a lot of times even the accused person may also be a victim of some kind. And so that's part of the struggle, if they too are victims of violence of some kind, it does have an impact on the determination of their sentencing. So again, it's dependent on the judge. It's dependent on what they hear and what is reported. Because now we do have Gladue reporters who write up those reports for accused persons, and so then you think that's the end of it. Either they're guilty or they're not guilty. But sometimes it's not the end of it, because the way the process works is that it's always appealable. So everything happens, the whole trial happens either in a provincial court or a territorial court, so at the provincial level. That's where all of the evidence is brought in, all of the arguments come in, and the lawyers on both sides. Very adversarial process. Adversarial meaning there's the fight between the two. And so if an accused is found guilty, and he could be spending time in jail for years, he could still win an appeal. Right? An appeal is up to the next level. So it goes from provincial court up to the Provincial Court of Appeals, and then all the way to the Supreme Court of Canada. So that could take years as well. So if it is appealed, it can be appealed by the accused, and if he or she wins, it could end up going back to trial again. And the process allows that to happen. That's one of in my opinion, one of the worst processes within that system, is for families especially, is having to go through that process over and over again. So a whole new trial is ordered, or it could be ordered by the judge in the appeal. So then they go back again. The Crown, the Crown and the lawyers, the defense lawyers, going through a whole other trial process. And if it is appealed to the Supreme Court of Canada, then the families aren't represented at all. I mean, the families aren't represented in any part of that process. But there's no new evidence brought in. There's no new information. It's all just paper.
What if there is new evidence?
If there is new evidence, the Crown would have to start all over again at the provincial level. And if somebody is charged and they've already gone through a process, they can't be charged with the same offense again. So even if there is new evidence, the Crown would have to determine the charges that would be laid, which would have to be different than the first ones that they've already been through. Again, that's part of the difficulty with that criminal legal process. I don't call it a criminal justice. It's not justice. It's not justice for any victims of crime to have to go through a system that does not take into account their emotional or spiritual well-being and the losses and the traumas that they have to go through. I think that's part of the difficulty with that system. But the more that people are aware of how it works, the more I think people, families especially, can be made aware right from the beginning that sometimes the real justice for them may not get answered in that process. And so it's the healing that has to take place away from that system. It's really not gonna help heal. It may help if they are charged and they are convicted. It may help in knowing that they're having to pay maybe for what they've done, but it still doesn't help with the fact that they continue on with their life and the loss of your family member is still gone, so that the traumas are still there. So that healing has to come directly from families and those that help them through that process.
So you've done a really good job of explaining the system. Let's talk a little bit about how people can get through it emotionally and intact, or just practically.
Yeah.
What kind of supports do they need? What should they be asking for? Where can they get the things they need?
So, in order to help families who are going through that system, is to make demands of having the supports available, whether it is counseling, grief and loss counseling, that can help to understand that, their loved ones are gone, and having the resources, because I know that trials can take a long time, and I think most family members attend those hearings every day, and take time away from their work, take time to go there every day. So those resources should be made available to families, and making those demands to government, to the Crown, to whomever is available. And I know that there's supposed to be family liaison units that are supposed to be brought to victim services. I don't know how that's working yet, or whether it's even been implemented, but that was one of the announcements by the Minister of Justice, to bring those liaison units into victim services. Inquire about that. Find out whether they actually exist, and if it doesn't exist, then get us activists out there to help you to make those demands, and to make sure that assistance is there for you. There's also the Criminal Injuries Compensation Board, making applications to getting again those activists out there to help you, getting those advocates to help you to make those applications. I know a lot of times family members, nobody's running. A lot of times family members may not feel comfortable maybe asking for those kinds of resources.
Can you explain what CICB is?
So basically what it is an application to this Criminal Injuries Compensation Board to request money, compensation as victims of crime. There are resources that are set aside specifically for victims of crime within that compensation board. So requesting those resources to help you through the system, because you do have to, and I know family members do go to court every day and leave work, asking for that. There's nothing wrong with asking for that compensation.
Who can ask for that?
Family members, victims of crime can request for those resources.
So you have to be blood family, biological family?
Yes. As far as I know, I'm actually just coordinating one now, and I'd have to double check that. I'm pretty sure you'd have to be a close family member to apply for that compensation.
Can you just say that in a full sentence and I'll check it and make sure it's true?
Okay. I'm pretty sure that it is close family, immediate family that can apply for the criminal injuries compensation.
And does that exist across Canada, or is that something?
It's national. Yeah, it is a national system.
Okay, if there are no resources from the state like that, what can community do? What
Yeah.
can you ask from community?
So this is where, one of the most important pieces to this that I have seen over the years is that a lot of families try to do this on their own. And I think, I really think that community has to be involved, close. Part of being Indigenous is that we come from a community, and that we come from a strong links between each other as families, as community. So I really believe that community should also respond in a good way to support all families who are going through this. And a lot of times community doesn't know how to help. They don't know because it impacts the whole community, and it can traumatize the whole community. And so again, asking the leadership to help, going right to the leadership and asking for assistance, whether it is helping our own Indigenous ways, right? We always have had a process of helping. So it's implementing that as well, not feeling, or feeling that you're feeling that you may be helping, or feeling that you are I can't think of the word.
Supported, lifted up?
Yeah. Sometimes feeling that you're interfering, right, in other people's lives, maybe, or that. But I think when you're in trauma and you have loss, and especially a violent loss like murder, that I think a lot of community members wouldn't hesitate to support in any way whatsoever. And I think that sometimes it's difficult for us to ask for help. But I think it's really important that we do get past that and ask for the help that's needed by whatever the resources that there are in community. There are mental health services, there's health services, there's elders, there's traditional leadership, there's traditional medicine. There's all of those resources that could be brought together to help you in any way possible, whatever that help is.
Now you're looking right at the families and giving a message to them.
Okay, now I'm going to be emotional. So my message to the families is to stay strong. It is a really emotional process to have to go through, very spiritual. Making sure that you have those supports around you at all times. You know, in all of this, all these years in meeting with families and knowing what families have had to go through, and then happening in my own family, I know exactly how it feels. I know how it feels when someone goes missing. I know how it feels when having to go through a murder trial. I know what it feels like to again have to go through another murder trial. So my love for you, and my feelings for you and having to go through such a traumatic experience. You know, there is really no words to describe what that feels like, other than to know that I love you very much, and you can get through it. You'll get through it. It'll be hard, but those spirits of those loved ones are right there with us, and they're there to help us through this. And so never forget that they're just right there with you, and they're there to help us too. Nyawa.